welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we discuss the AAA ICDR Mass Arbitration Supplementary Rules, which we'll refer to as the Mass Arbitration Rules, with Adam Shoneck, who is the AAA ICDR's Vice President for Business Development and Outreach. For those who haven't been following, this is the third installment of a multi-part mini-series we're doing on mass arbitration, which has been a really fascinating educational experience. I'm sure you'll find this episode with Adam and the AAA educational as well. Let me begin by doing some introductions. I'm JP Duffy. I'm an international arbitration partner at Bracewell based in New York that acts as both counsel and arbitrator in arbitration seated around the world under a variety of governing laws and arbitral rules, including the AAA commercial and ICDR rules. And I've had the good fortune to be listed on the AAA commercial and ICDR arbitrator rosters for many years now. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I used to live and practice. As I mentioned, with us today is Adam Shoneck. Adam is the Vice President for Business Development and Outreach at the AAA. Adam works in the consumer and mass arbitration sectors and helped draft the AAA's mass arbitration rules and consumer rules. And he's been with the AAA for 16 years since graduating from Penn State Dickinson School of Law. So as you can tell, Adam knows the mass arbitration rules in and out, and we're really fortunate to have him with us today. So welcome, Adam.
Thank you so much, JP.
Let me begin by just giving some brief background on the AAA ICDR for those who don't know it, because we're going to be hearing a lot from the organization this year. It's reached a very auspicious milestone, which is the 100-year anniversary. So for those around the world that are less familiar, the AAA ICDR is a nonprofit alternative dispute resolution services provider headquartered in New York that administers arbitrations, mediations, and other forms of dispute resolution, such as budsperson and dispute avoidance training. It was founded in 1926 to provide an alternative to civil court proceedings, making the AAA one of the oldest arbitral institutions in the world, as well as one of the largest, having administered over 12,000 business-to-business cases in 2025 alone, with a total value of $29.1 billion. Notably, the AAA has several divisions that offer users substantial subject matter expertise. For instance, the commercial division specializes in business-to-business disputes of all sizes, but has particular expertise with large, complex cases across a variety of industries, including accounting, communications, energy, entertainment, financial services, franchise, hospitality, insurance and reinsurance, life sciences, sports, and technology. There are also separate AAA divisions that focus exclusively on construction, consumer, employment, government, healthcare, and labor disputes, with the consumer and employment divisions being particularly relevant to our discussion today. Lastly, as many of our listeners will be aware, the AAA ICDR has a well-known international division, which I've alluded to, the International Center for Dispute Resolution, or ICDR as it's known, that focuses on disputes that have an international component. As I mentioned at the outset, 2026 is the AAA ICDR's 100th anniversary. And to mark that occasion, we'll be having Bridget McCormick, who is the AAA's president and CEO, as a guest later in the year to discuss various topics, so stay tuned for that as well. But back to what we're talking about today, which is mass arbitration with Adam, because he's a true mass arbitration expert. So thank you again, Adam, for joining. We really appreciate having you here today.
Thank you for having me. Appreciate it.
Great. Well, perhaps you could begin by explaining mass arbitration to the audience a bit.
Sure. So mass arbitration is a relatively newer phenomenon. It doesn't exist except for the fact that consumer and employment clauses have class action waivers. And so there's a well-known case, Concepcion, AT&T v. Concepcion, that went to the Supreme Court that said that businesses could include class action waivers in their agreements. And as a result, that meant consumers and employees could not bring a class action against businesses. Instead, these businesses were directing individuals to arbitration. Concepcion was decided in, I believe, 2011. And between that time and about 2019, we saw some initial attempts to file a mass arbitration. It really kicked off a little bit later, but essentially plaintiffs' lawyers figured out that they could get together a whole bunch of individual arbitrations and file them at once to put procedural and fee pressure on the businesses.
So let me just unpack that a bit. Really, what this is an aggregation of individual claims that are all filed at once involving a similar event or a similar respondent or something common to all the claimants, whereby all the claimants are filing at once, seeking, I assume, sort of similar relief, right? Okay, now you mentioned employment and consumer. Are there other contexts in which this can arise?
We've only seen it so far officially in the consumer and employment context. However, there have been at least one or two commercial mass arbitrations that were threatened, and we can conceptualize a construction mass arbitration where you may have maybe a national home builder, a very large home builder, where there's a sort of common defect among many homes that you would need to aggregate all those claims together. So it's possible in those other contexts. It just hasn't officially come through as a mass arbitration yet.
Got it. So it's most common at the current time in employment and consumer, but there is the possibility for other areas to have this pop up. And I guess we're going to talk about it more, but I think that's something the AAA rules anticipate too as well, if I'm correct.
Correct. You can imagine a scenario where there are many online sellers who are operating as businesses against a large platform that may bring similar claims against the platform. So that's how we get a mass arbitration in the commercial context, at least so far.
Interesting. Now, you mentioned Concepcion in 2011 being sort of the genesis for a lot of this. When did the AAA first really start seeing mass arbitrations?
The first large ones that we really think of as mass arbitration started in 2019, but there were a couple before that in the years preceding that set the stage a little bit. But it wasn't until 2019 when we saw some mega mass arbitrations, as I call them, in the tens of thousands of cases against various companies.
Now, was that in 2019, was that a function of that's when the plaintiff's bar figured out their playbook, or was there some other event that drove that, do you think?
No, I think it was the plaintiff's bar figured out at that time that you could do this in mass, so to speak, and really brought it to the fore.
Got it. Now, how did the AAA handle mass arbitrations before introducing the mass arbitration rules?
Yeah, so what's interesting about mass arbitration, just like anything in the arbitration context, is the contract controls. So these cases were coming in, the contract calls for individual arbitration, and accordingly, we were handling them all like individual arbitrations. There was no process arbitrator role or neutral to oversee everything. They were all literally just individual cases. That turned out to be a headache for all parties, and that's really what led to the introduction of the Mass Arb rules.
Okay, now, when did the AAA first consider introducing mass arbitration rules then? Was it around that time, 2019?
Yeah, and we released our first, what we called at the time, multi-case filing rules. We didn't call them mass at the time, but in 2021. So it was just a little bit after those initial cases had resolved that we released those new rules.
And talk to us a little bit then about how they were drafted. Like, how long did it take? What was the process? Who was involved?
It was only AAA individuals who were involved in the drafting. So we did not go out and solicit advice, from either side. We took about maybe 6 months or so. And it was a lot of internal discussion and a lot of back and forth as to different aspects of things. We took pieces from different rule sets to make sure that everything was enforceable and correct as far as language-wise. So it probably took about 6 months to develop and publish them.
Well, that's relatively quick. That's a pretty big undertaking for 6 months.
Yeah, I think we had the basic outline pretty quickly, and then we just needed to figure out some specifics from there and then get it approved and whatnot. But we were working very hard on these rules to get them out so that if we got another one of those mass arbitrations, mega mass arbitrations, we would be ready to handle.
Now, you mentioned that a couple of times, mega mass arbitration. What industry or what sort of subject area did the first mega mass arbitration pop up in for you?
They were both in the consumer context, the first two mega mass arbitrations. I say mega because these are caseloads in the tens of thousands. It's interesting because our threshold is 25 cases for triggering the mass arbitration rules along with some other requirements. But we see small mass arbitrations, which are, maybe 100 or less than 500, and then medium-sized mass arbitrations, and then the mega ones. And they all behave a little differently. The smaller ones, the parties tend to be much more agreeable and working towards solutions. In the mega mass arbitrations, the stakes are so high that generally the parties are at a deadlock on almost every issue. Interesting.
Now, what's sort of the threshold at which you would start to call it like a mega mass arbitration?
Probably over 5,000. It's not a well-defined term, but when you start getting into the thousands, that's when the stakes get a lot higher for both sides.
Yeah, that's quite a number of cases. Well, let's talk about that a bit. Let's transition and talk a little bit about the mass arbitration caseload. How many matters has the AAA administered under the Mass Arbitration Rules since their introduction in 2021?
I don't have exact statistics for prior to 2024. However, it's been in probably the several hundred mass arbitrations that we've handled. Individual cases is around 150,000 plus, but those aren't all 25. Many of those are many thousands of cases part of one mass arbitration. So I would say a couple hundred since the rules were introduced.
Wow. Now, how many did the AAA administer in 2024?
So in 2024, there were 92 total mass arbitrations, 82 on the consumer side and 10 on the employment side.
Okay, 82 on the consumer side, 10 on the employment side. So much more heavily weighted towards consumer.
Yeah, but what's interesting is in 25, for example, it was more heavily weighted to the employment side. So it can vary for sure. Consumer is a little easier context to get claims in, I believe. So that's probably why we see more consumer mass arbitrations, plus the prevalence of consumer arbitration agreements as well.
Okay, are those consumer arbitration agreements arising in specific types of contracts, like terms of use or something like that?
Yeah, terms of service, terms of use, those are the biggest drivers of mass arbitration. Companies have many more consumers than they do employees. And so it's easier for a larger group of consumers to be affected by something than necessarily in the employment context.
Got it. That makes sense. Now, what are some of the industries that these cases are coming from?
Yeah. So in 24, we saw a huge amount of cases, over 100,000 in the gaming entertainment sector. And that is really tied to, one, you have a consumer-facing company that has a lot of users. So that's attractive for the plaintiff's bar. They have an arbitration agreement, which is popular in the tech and gaming space. And then the types of claims that can be made were particularly relevant to that space, at least in 2024. So we see a lot of antitrust, and RICO type claims. We see specific to the gaming and entertainment space. A lot of these were like gambling websites. So it could be things like loot boxes. It could be other gambling type claims. It just happens to be like a perfect storm for consumer cases, which is why we saw so many in that sector in 24.
Okay, wow. Interesting. And you said those claims were in the nature of things like RICO and antitrust and claims of that type.
And then you've got your correct. And you've got your vanilla regular run of the mill consumer protection statutes as well that come into play. But I always find the antitrust, the RICO aspect to be particularly interesting in arbitration.
Now, Adam, that was in the consumer context. What are some of the industries you're seeing this come up in the employment context?
Yeah, any industry that has a lot of employees, maybe independent contractors, that's a very big one. Types of claims are misclassification, failure to pay overtime, can be discrimination as well. So we see a lot in the technology space and employment. One, because tech companies like to use arbitration clauses. They like to use independent contractors as well. You know, there's a large number of companies that use independent contractors for delivery services and gig economy services. And so we see lots of cases that come out of that context.
Got it. And if my memory serves, one of the first real big challenges or issues with this in court involved a gig economy, independent contractor delivery service type claim, right?
Yes, that was one of the big mega mass arbitrations that we handled earlier on.
Right. Okay. Now, you mentioned earlier, too, the possibility to have these arise outside of the consumer and the employment context. The rules are written so that that's possible, correct?
Correct. Yes. We've seen it threatened and almost go forward, but none have gone forward yet. But I mentioned you could have sellers against a platform, an online platform. You could also have merchants against, for example, a credit card company was another one. So those are commercial type claims rather than consumer or employment. And we wanted to make sure that these rules could apply in any of those contexts. Really, anytime the requirements of the rules were met, we wanted to be able to apply the mass arbitration rules.
Okay, that's a really interesting differentiator too, because I think most of the rules at other institutions are written with sort of specific areas in mind. That's an interesting distinction that the AAA rules are written such that they could apply beyond those two very common areas, which is really interesting.
Yeah, they were written as a supplement. I mean, that's per the name, Mass Arbitration Supplementary Rules, so that they could apply to any of our rule sets on top of those other rules and have those procedures apply.
So then would it be possible to have a case administered by the ICDR that also had the mass arbitration rules apply?
You know, we have seen plenty of international cases as part of mass arbitrations where we have administered cases in Greece, in France, in Canada, all over the place. So yes, you could have a purely all international mass arbitration, but really it's more that these cases that are already part of a larger mass arbitration happen to be international mixed in with U.S. individuals as well.
Interesting. Okay, so well, that's a really interesting point as well, that you've actually administered cases that have fallen under these rules that arise around the world.
Yeah, absolutely. And it's a challenge like it is anyway to find an arbitrator and then to explain to them what's going on and the procedures that are involved and whatnot. But we've been successful in that. So we're very proud of being able to take on all types of cases.
Well, that's interesting. Well, let's drill down on that a bit and talk about some of the mass arbitration mechanics. I think you mentioned earlier there's a 25 case threshold for the mass arbitration rules to apply. Is that correct?
Correct. And there's nothing really magical about that number. We just saw that 25 was was a good threshold and settled on that. The other requirements are that the counsel has to be consistent or coordinated across the cases. So you need at least one law firm on the claimant side, and they may be working with other law firms on the claimant side, and then one or coordinated counsel on the respondent side as well. So if they had different counsel, they weren't coordinated, they could be separate mass arbitrations, which we've seen a number of instances of where an individual company is facing several mass arbitrations at the same time because they're brought under different claims. In other words, the demands aren't similar enough, the claims aren't similar enough, and the counsel is not coordinated. So those get routed into being their own mass arbitration group.
Okay, so one respondent facing multiple mass arbitrations involving different sets of counsel and different sets of claims, but presumably similar, arising out of a similar instance or similar set of facts?
Correct. Yeah, it could be even the same claims, but brought by different counsel groups, and those are then treated as separate mass arbitrations.
That's got to be an interesting position to be in as the respondent. Now, can parties impose the requirements in the arbitration clause that the mass arbitration rules apply, even if those conditions you just mentioned earlier aren't met?
That's interesting, and I think maybe more academic. I guess they could. I don't know that in practice they would. I mean, theoretically, it would be a caseload of less than 25. And in that circumstance, the stakes aren't very high. So parties probably aren't going to go for the mass arbitration rules. It would be very difficult, I think, to impose the mass arb rules if something like the claims weren't similar, the counsel was not coordinated, some of those other requirements not being met. It would be pretty difficult. And I think we would sit down with the parties at that point and really try to hammer out a process that works for them. Whether we call it the mass arb rules or not, we try to work with them on a process that works.
Yeah, that makes sense. And one of the reasons I raised that is I was having a really interesting discussion with someone yesterday who operates on the claimant side of these types of claims. And we were talking about, sort of the cat and mouse game of drafting in this space that's gone on since Concepcion. And that was one of the things that popped into my head. And what safeguards does the AAA have at the filing stage to ensure that cases are legitimate?
Yeah, so as part of our update to the Mass Arb rules in 2024, we imposed an attestation requirement. The filing attorney has to attest that the information contained in the demands and the other filing documents are true and correct to the best of their knowledge. It tracks the language of Rule 11. It doesn't copy it word for word, but it's generally meant to impose that sort of requirement. Claimants also have to file individual demands for every single case, and they have to fill out what we call an intake data spreadsheet. And each individual's name has to be listed along with other identifying information such as their email address, their home address, their claim amount, etc. So we look at those spreadsheets when it comes in to see if there are any obvious errors or potential, I don't want to call them fraudulent, but illegitimate claims, I guess we could say. For example, where the claimant's name is Bugs Bunny, which we have seen. And, that's probably a result of the claimant's lawyer has their sort of intake software that they use, and it didn't catch, that this person put in a fake name, and it just gets put on the spreadsheet and then sent to us. So as a neutral administrator, outside of the situation where it literally says Bugs Bunny, we don't have a lot of power to say, well, I see this guy's name is John Smith. Is that a real name? So there's a lot of incentive for respondents to also look at the spreadsheet and tell us, hey, we don't think this person is legit. We'll then ask the other side for their comment, and a lot of times they will withdraw the case. That also happens with claimants that one side alleges are deceased, or the other area would be where they've never purchased the product, or never were a customer, or never were an employee in the employment context. And so, although we don't have a program to really suss those out, the parties generally work very well with us in getting out any illegitimate claims at the start. The process arbitrator also can play a role there and make decisions on legitimacy of cases during the process arbitrator phase. So we have some administrative steps that can catch some of these, but really it's the process arbitrator who can make those sorts of decisions.
Well, let's talk about that for a second then. What is the process arbitrator? Where in the process does that begin, and how does that all work?
Yeah, so under our initial draft of the rules, you paid for all the cases and then you got a process arbitrator. The problem was, with disputes about how many people there actually are in the mass arbitration, it's hard to charge fees based on how many people there are because that issue is in dispute. And so what we said was, okay, let's just do a flat initial fee, and then the parties can get a process arbitrator right away to start deciding some of these issues. And that has worked extremely well. The process arbitrator phase starts right after the filing, once the filing requirements are met. And we will give the parties either a list to choose from, or we will appoint the process arbitrator. It's almost always a list. We want them to choose a process arbitrator from a list, but we will appoint if we have to. But that process arbitrator has broad authority to decide any non-merits issues that might arise, as well as some specifically enumerated issues that typically come up at the outset of a mass arbitration, such as what rules apply, what fees apply, who pays what fees, whether the preconditions to filing were met. That's another very big argument at the outset of a mass arbitration is, did all these consumers or employees meet the contractual requirements before they filed their arbitration? And the process arbitrator can decide that.
And sorry, I may have just missed it, but how is the process arbitrator appointed?
So we give the parties a list to select from. We have authority to appoint the process arbitrator, but in practice, we would prefer to give the parties a list to select from, since it's a more collaborative process.
That makes sense. Now, the mass arbitration rules also have a mandatory mediation requirement, right?
That's correct. Yeah.
Tell us about that a bit.
Sure. So I'd have to put mandatory in quotes since either party can opt out of that process. But in most mass arbitrations, parties have mediated before they even come to us. And so at the outset of a filing is usually not the right time for mediation since they've already just done it. But there is that requirement that they mediate. And again, in practice, it's not an issue. And then either party can opt out of that if they'd like. Sometimes mediation is just more effective down the road.
Now, when you say either party can opt out, obviously are we talking in individual cases, or are we talking about if we're talking about the claimant side, at what point would that opt out come? Is that in the individual case stage, or how does that all work?
Generally, that would be at the not at the individual case stage. It would be at the stage where a process arbitrator is being appointed that we generally try to get them to mediate. So I guess an individual claimant could opt out, but really it's their counsel who's speaking for them at that point and participating in the mediation.
Right. Yeah. Because if you're the respondents, you have you're the respondent, you have a very strong incentive not to mediate if it's going to be individual opt-outs, right? Like you want to get, I would assume, to some sort of global resolution at that point.
Correct. Yes.
Okay. So let's say the parties go through a mediation, the mediation fails. What happens then?
Then we're usually appointing the process arbitrator.
Mediation happens before the process arbitrator.
Usually, yeah. Mediation usually happens before they even file with us. And then they file and we get the process arbitrator on board. But if they haven't mediated yet, as soon as we get the filing, we're going to ask them, have you mediated? Let's think about this. Here's some people we could recommend for you. And then parties are usually very agreeable to mediate. That neither side wants to be the one who said no to mediation. So they want to see if they can get this resolved.
Okay. Then they've gone through the process arbitration. So you get the process arbitrator appointed. That person presumably creates a process for how these are going to be resolved. Well, this is actually an interesting point here. If I've understood it correctly, unlike some other institutions, part of the process intentionally doesn't involve using bellwether or test cases. Is that right?
Correct. Yeah.
Okay. Why don't maybe you could explain that a little bit for people that are less familiar, like how does that work and what was the rationale underpinning that decision?
You have to be very careful in writing Mass Arb procedures as an institution. There's several cases out there. The most important one is Heckman v. Live Nation that really set out some of the very important factors for determining whether a contract is conscionable or not in the mass arbitration context. And one of the things that the court really honed in on was you cannot have rulings going out that would affect people whose claims potentially hadn't even arisen yet. So follow me on this, that let's say I'm a user of a platform to buy something. I go to that platform and I buy something and it turns out, there's a dispute. So I pick Joe Smith as my attorney. Well, it turns out Joe Smith represents at least 25 other people and has brought a mass arbitration against this company. And just by me picking that attorney to be my representative, if there were bellwether cases that applied down the line, then my case could already be decided before my claim arose, just by virtue of the fact that I picked Joe Smith as my attorney. And so we had to be very careful that situation could not occur, that a decision could be binding on somebody who had no ability to participate or even know about the process prior to selecting their representative. So we decided we could not do any sort of bellwether or test cases because of that potentially binding aspect on later filed cases. So that was a very conscious decision of ours not to do that. Another thing is, how do you pick the test case or the bellwether case? If you've got 1,000 people and you just decide, all right, everyone else is going to wait while this one goes forward, it's not quite fair in our estimation to, at least for us, the AAA, to be able to pick that case and decide that this is the one that's going to affect everything else down the line.
Yeah, I mean, that's a really interesting point because I know some institutions do it by things like, every 10th case or something like that. But that is a really interesting problem. And I think the other one that you highlight that I could see as a potential issue is not just saying that parties that filed after the bellwethers were selected were bound by those decisions, but also people trying to game that. Right. I mean, I would see the ability for people to hold back claims or to say, no, look, I filed after that came out. I could see that being a very heavy administrative burden when you're talking about claims that rise into thousands, the thousands at once.
Correct. Now, certain contracts call for bellwether and batching is a little bit different. And we don't take a position on that. I mean, courts have ruled now that certain types of bellwether clauses are unconscionable. So contracts may impose this sort of requirement, but we felt our rules could not do that.
Adam, let me ask you, statistically, most of these cases settle out, right?
Correct. It's about online with individual case statistics as far as settlement.
Oh, it is. Okay. So the settlement rate is about the same as individual case settlement rates?
Correct. Yeah.
Okay. At which point is there a common point in the process at which these typically start to settle?
After the process arbitrator rulings have been made and that phase is complete, that's typically when we would see the highest rate of settlement, because that's when merits fees start kicking in. And those can be the very large fees that companies are worried about. And also because the process arbitrator has made several rulings on key issues, that sort of sets the playing field for the parties, and they maybe don't need the merits decisions. A very small percentage go through to final awards. My interpretation of that is that parties don't need all those merits decisions in order to figure out where they want to settle. That being said, in the consumer context, we saw a 30% dismissal rate in 2024. Arbitrators were still making decisions in more than 30% of cases. It's just that they weren't all going to award.
Okay, so they weren't all going to like a final hearing on an award, but there were dispositive decisions being made or things of that nature.
Correct.
Okay. Have any awards under the Mass Arbitration Rules been enforced?
As far as I know, there's at least one process arbitrator ruling that has been enforced by a court from the AAA, and I think another one from another provider as well. As far as the merits decisions, I don't know for sure. That would depend on whether the parties are going to court to have those confirmed. But definitely process arbitrator rulings have been enforced.
Wow, interesting. Well, let me shift gears a bit and ask you about where you see this all going, because it's such an interesting and dynamic area. What do you see as the future of mass arbitration?
Yeah, so on the clause side, I was expecting, there's a case called Jones v. Stars, which is one of those process arbitrator rulings that was upheld, where JAMS consolidated a number of cases into one matter. And the court blessed that. And I was thinking that clauses would shift to allow for more consolidation, because you can save a lot on the fees that way by having one case instead of 100, for example. I haven't seen it, but I have seen more and more counsel who are interested in that approach. So I think from the clause drafting side, we will see more consolidation of cases in concurrent batches. So a batch would be, 10 or 100 cases all heard by the same arbitrator at the same time. And then if you go a step further and consolidate those cases into one, so there's only one award, you can save a lot on the fees. So I think that's where we may see clauses go. On the administrative side, we're constantly improving our technology to administer these and seeing more and more development around the space. And so I think you'll see changes in rules and changes in fees to make it a smoother and cheaper process overall.
Okay, so there are some thoughts then about perhaps updating the mass arbitration rules?
We always get feedback about it. It's a very new area. And so we tried with the initial version and then we updated it in 2024. And so I think there is room for the rules to evolve with how mass arbitration is evolving, especially with the case law evolving and clauses evolving and different practices coming out. It's becoming a much more mature practice area. There are claimants firms that do solely this or pretty much only this, and they've gotten good at gathering clients and figuring out how to manage that. It is a niche practice area, and I do see the procedures evolving with the times as parties want a different process.
Well, Adam, this is really fascinating and it's really, really educational. So thank you. I think we should plan to circle back on this topic again in the future, particularly if there is a rule update that comes out, because this is such a dynamic and evolving area that there's stuff to be discussed that could go on all day. But In the interest of time, I think we'll conclude our discussion of the Mass Arbitration Rules with the expectation that we're going to be having Adam back to give further updates on them in the future. I want to thank our guest, Adam Shoneck, for enlightening us about the Mass Arbitration Rules, and I want to thank you, the audience, for listening. You should feel free to reach out to Bracewell about today's podcast with any questions you might have, as well as to Adam. And we look forward to having you tune in for future episodes in our Arbitration Acumen series, and particularly the other installments in the Mass Arbitration miniseries. So, Adam, thank you so much again, and we appreciate all your insight, and we look forward to having you back in the future.
Thank you so much, JP.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.